spot. Oh, look at that. So now, hopefully everybody in the audience sees 3 extremely handsome, extremely wise gentlemen. Is that correct? At least 2, right?
You two, yeah, you two. The handsome.
I don't know about the handsome part.
Yeah. So Jason, if you wanna tee this up, and then we can pick it up from there.
I don't have much to say, but I just wanted to welcome everybody to the Lease and Legal Seminar. Traditionally, John and our John Baldwin and our attorney at the time go over the lease, go over legal issues. They're always a wealth of information. So I know we have a lot of people signed up tonight. Great to see everybody. And I just want to give a special shout out to Adam. I know, he's really stepped up over the last year for our organization in a lot of ways that people haven't seen, on a lot of behind the scenes things that he's helped us out on, with everything from getting district magistrates to start hearing eviction hearings again. I know he'll talk a lot about that tonight, but, I just want to give him a high five and a round of applause for doing that, because, we could really be much further behind the 8 ball. And I think, those of you that may have some questions, I see them pop up on a lot of the different Facebook groups, rather than get into long dialogues on Facebook about it. I think some of the, Adam will be able to answer some of these questions and help you get some of your, current legal issues with tenants solved.
I have no idea where the volume is on this.
So that's all I have, Adam. And without any further ado, if you want
I have no idea where the volume is.
And sounds like somebody else is unmuted here, so we'll probably mute me and mute.
Oh, sorry.
Yeah. So if your name is not John Baldwin, go ahead and mute yourself. And then I know Mike is in the crowd, and eventually I'll bring him up. All right, Jason, I'm going to remove the highlight here, or the spotlight. There we go. Cool. Hello, everybody, and welcome. I recognize a lot of names in the participants registry here. My name's Adam Williams, and I'm the solicitor. And I think this is the 3rd or 4th year I've done the Lease and Legal Seminar with John. And usually, honestly, it is the John Baldwin show, because he knows more about successful landlording than anyone, probably. At least anybody that I know, or whatever. But this year, John and I spent a little bit of time preparing for this, and kind of decided that the changes were so fast and so furious this year, and we really stayed on top of them because we had to field all the phone calls, that this year I'm going to do most of the talking. And if you've ever been to a presentation or been on a webinar that I've done before, you'll probably see the number of participants drop off very rapidly here as soon as I break that news to everybody, because no one will want to listen to this. No, but I kid. And so that's one of the very important things that you need to understand about me. If we haven't talked, if we haven't done business together, if you haven't been to another presentation, I take my job very seriously. I do not take myself very seriously. So there will be bad jokes, there will be offhand comments, but for the most part, this should be a pretty good presentation. So what I'm going to try to do here, and I got too many screens going at once to do this, I'm going to try to share the PowerPoint that I put together. Don't worry, we'll send this out after the fact, and you'll be able to see it, because there's a lot of these slides have a lot of words, because it's pretty nuanced stuff. There's a couple important links that are in there. So yes, you want to take notes. Yes, you want to write things down if you have questions at the end. But we'll send these out so you'll have them too. So let's take a shot at sharing our screen. All right, so you should be looking at my PowerPoint presentation right now. Someone nod if that's the case. Okay, cool. All right, so here it is. Like I said, I'm Adam, John is here, and then we also have attorney Mike Micsky from my office, because there's a couple of topics that he's going to cover. For those of you that don't know about us and don't know about what we do, I literally changed the name of our law firm on Monday. We are now Rust Belt Business Law. Part of the reason for that is it's going to allow us to expand a little more geographically than our prior name, which was a little limiting. And as of now, I think we're up to 11 employees. This picture isn't completely up to date, But in December, we were named the number 68 fastest growing law firm in the entire country. We were number 2 in Pennsylvania. And we're doing that right here in Erie, Pennsylvania. So when you hear about things that I've done for the association or things that I've been a part of, it's really our entire team. Every time you call, someone else answers the phone, usually Kylie. Some of you may talk to Sean. Some of you may talk to Attorney Micsky or Attorney Kilmer on issues. So very little of what we talk about being up to speed on, very little of what we talk about doing is me directly. It's really our whole team. And like I said, I think this has got to be my 3rd or 4th Lease and Legal. Usually I get to go out for drinks with you guys afterwards, but that's not happening this time. All right, I'm sorry. I had to include one bad COVID joke, which if you Google COVID jokes, there are some good ones out there. Most of this topic is going to be about COVID related stuff, although we'll get into some other normal landlording things, if you will. So you're gonna see this slide 6 or 7 times because I want to sort of roadmap where we are throughout the presentation. I'm gonna run through the moratoriums and what's currently in effect, what the current law is, and some of the things that have expired, because I think that's important. I'm gonna go over a couple of the rules, changes to the rules for the magisterial district judges. One of these happened at the end of January, and you may not know a lot about it, but it may become a massive headache for you, so you're gonna wanna listen up. And then I'm gonna turn it over to John to talk about some new changes. He actually was able to send out an update through PROA, I think, to the entire membership, but he's been a lot more up to speed on the new rent and utility law than I have. We'll come back to me, actually, to Attorney Micsky to talk about assistance animals and some general fair housing things. This is an area not COVID related, just run of the mill, I guess, landlord nightmares. So he's going to talk a little bit about that. I want to mention some things about notices and providing notice to your tenants when they're in violation. I want to talk about some issues with prior landlords, meaning people that owned real estate before you guys did, and then we'll get into some Q&A. So I'm going to try not to ramble too much. We're going to come back to this slide a couple of times so you can see where we are throughout this process. But I do want to make one thing abundantly clear, because this happens on 80% of the phone calls that I get. None of these changes were my idea. None of these laws were written by me. They actually didn't even ask for my input on this. So don't yell at me. I know all of this stuff sucks. I know all of this stuff is favorable to tenants. I know all of it costs you a lot of money. I'm not sympathetic. I don't own residential real estate for a reason. Dealing with this crap is a freaking nightmare, right? But this was not my fault, so don't yell at me, all right? Good. I can't see enough videos to know if anybody's even reacting or paying attention to what I'm saying, other than John. John laughed at that. He gets it. Good. All right, first thing I want to talk about, the moratoriums. I don't know the plural of moratorium. It might be moratoria. So if someone wants to educate me on that, I would really appreciate it. But these are some of the ones that we've gone through in the past year. So the first one was in no particular order, was Governor Wolf's moratorium saying no evictions. That went May through July, and then he extended it. And we told you guys to prepare for that August 31st deadline. I think everybody rushed into court September 1st because they were giving notice in advance of that deadline. And I think that went, for the most part, pretty well from what we heard on our end. But it's over now. So good news, you survived it. Great job, everybody. The second moratorium that we had to deal with a lot was from the CARES Act. And the CARES Act was the big law back in April or whenever that was passed that had all the PPP and all the other pandemic stuff that we hear about. That one went through July 24th initially, and then there have been some extensions on it for some different types of evictions. I don't think any of those evictions affect you guys. I think they're actually continued through the end of March now. These are the types of mortgages that are like Fannie and Freddie backed. I don't think they really mean evictions. I think they mean ejectments. So if you have a federally backed mortgage on a single family residence and you default on that mortgage, I don't think they can eject the owner from it. I don't think it affects you guys. So we've survived that one too. Again, good job. So the last one is the CDC moratorium. And we do not have enough time tonight for me to tell you how ridiculous this is. You guys all know that it's ridiculous for a number of reasons, but there's a million more reasons that you're not even aware of. But the Centers for Disease Control came out and said, you can't evict for certain reasons, and it's a public health issue. And that was their justification, and that's why the Centers for Disease Control has control over it. So this is the one. This is like the reason that most of you are tuning into this program. This is the reason that most of you are complaining on Facebook about what all of the judges are doing. This CDC moratorium is what's creating all the issues. I'm going to try and teach you as much as I can about this. What I've tried to make abundantly clear to everyone is I think it would be a bad idea if you took what I taught you here and you ran into some judge's office and waved this in their face and said that they're wrong. There are good ways and there are bad ways to tell a judge that they're wrong. That would be a bad way to do it. But let's talk about this moratorium. So the CDC, this is, again, the big one, says you cannot evict for reasons related to payment of rent. That's it. You can evict for a million other reasons, every other violation in the lease. So if you're evicting for non-payment, second item on there, if the tenant signs the declaration and presents it to you, from now, as of now, it's through the end of March, through March 31st, you can't evict them. That's the general rule. We're going to dig deeper into this. You can still evict for all these other reasons, and we're going to talk about what reasons there are in the next couple slides. Here's what the declaration says. And I highlight some of these words because these are the words that lawyers really like because they have meaning. And the meaning is sometimes subject to interpretation, which means we get to argue things, which means people are paying us, so we're happy. But if a tenant is going to stop the eviction under the CDC declaration, they're promising all these things. It's like an affidavit that they sign. It says they've used best efforts to get all available governmental assistance. And I know a lot of you guys dealt with this because these tenants were not availing themselves of all available government assistance. You knew they weren't applying for the CARES Act money that was out there. Second thing is there's an income cutoff. Third item is it says they've suffered a substantial loss of household income. So if they haven't lost their job or they're still getting their Social Security disability or whatever it is, if they haven't had a substantial loss of income, they don't qualify. The next bullet point says they're making best efforts to make timely partial rental payments. Best efforts is an extremely high standard. Attorneys like to talk about reasonable efforts. That's a couple of degrees below that. So they're making their best efforts to make at least partial rental payments to you. So if they're paying you zero and they still have income coming in, they're probably not using their best efforts. Next bullet point says they're basically going to be homeless if you evict them, whatever. Second to last bullet point says they still owe all rent and fees and penalties and interest due during this period, right? So it still accumulates, it still adds up. It's going to increase the amount of the judgment that you're going to get against them. And I don't think some tenants realize that. I think some tenants think, I just don't have to pay rent for a couple months, right? And then, like I said, as of March 31st, we can go back in and evict. So if the tenant signs this declaration, or if there's a threat that they're going to sign it, or you think they might sign it, you need to look for reasons other than non-payment of rent to evict them. And I have to be very careful with my language on this, because when I say look for other reasons to evict them, I'm not telling you to make up reasons. I'm not telling you to lie, but I'm telling you to thoroughly understand your lease, thoroughly understand what the tenant's responsibilities are, and find out if they're meeting those responsibilities. So I put a handful of these numbers on here match the paragraph numbers in the apartment association lease, which if you're not using the most up-to-date version of the apartment association lease, stop it. Use the most current version. 2015, I think, was the copyright date on it. These are the paragraphs that you want to look at. What the tenant has to pay for, non-rent, right? This is utilities and all the other stuff that's on that first page. If they've done damage to the rental unit, if they don't have rentals insurance, if they're not using the unit the proper way in paragraph 9. Paragraph 11 allows you to have rules and regulations that they may or may not be following. Paragraph 13, if they're not caring for the rental unit properly. 16 is if they're not paying utilities. These are all reasons other than non-payment of rent for which you can still evict. So make a note of these. If you have a client who fills out the declaration and you're not sure what to do, or like I said, that you think it may happen, these are things that you should include in your eviction paperwork. All right. I got to scare you a little bit. If you screw this up, right, if you still try to evict, even with the declaration signed, if you do this the wrong way, you're going to go to jail. You're going to pay a whole bunch of money. And it turns out it's more money if your rental's owned by an LLC or a corporation, which is kind of interesting. So there are big penalties for getting this wrong. It's not as if you're going to be able to force through some eviction, because you know the judges are very cognizant of this rule. But if there's other things that you do that violate the spirit of the law, the penalties can be pretty bad. I'll come back to it. Okay, so again, this wasn't my idea, right? I think this is a bad thing. The issue is when the CDC moratorium started months ago, the rules were quite unclear. And then we were able to get some clarification on the rules. And then we knew that the district judges weren't all following the rules. So here's what we've done about it. On November 12th, Judge Trusilla issued an order that said, if a tenant fills out the CDC declaration and they lie or they do so improperly, the landlord can challenge that now. There was no process in place prior to November 12th. Your tenant could lie out of their teeth, and the only repercussion was theoretically they were going to get prosecuted for violating federal law for lying under oath. But we all know that wasn't going to happen. So we were actually able to sit down with Judge Trusilla and his law clerk, and we wrote this process. We created the forms to allow you to challenge these declarations. I want to see, I thought I had a slide on how to challenge it, and we may come back to it. But there's a process in place. So if your tenant has signed this declaration and they've lied, or you don't believe what they had to say, or you know they haven't exhausted all their options, or if they think they're not going to have to owe you rent for this period of time, there's a process in place to fight it. There's a form to fill out to do it. It looks just like a landlord-tenant complaint. You're filling in the blanks. It's a really easy thing to do. But there's a process in place. So that was some of the magic that our office was able to work this year, because it was a big problem, right? What these tenants were doing. So we've got a process in place now. It was a November 12th order from Judge Trusilla. It was emailed out to the entire membership. So we're good there. I know more recently that even though the moratorium makes it pretty clear you can still evict for reasons other than non-payment, there are still a small number, a number maybe as small as one district judge, who just aren't accepting these complaints at all. I know that's wrong. I know that's not what the law says. The issue is judges are very hesitant to tell other judges how to do their job. But I have reached out to Judge Walsh, who's now the president judge. He replaced Judge Trusilla at the beginning of the year, and we're working on it. That's the best I can tell you at this point. I know it's not fair. I know that it's an inconvenience. I know it's costing you money. So we're trying to work on it. And in case anybody's wondering, it's Judge Carney, right? You all know that. But we've heard issues with Judge Beveridge, which I think are resolved. We've heard issues with Judge Strohmeyer, which I think are resolved. But if anybody hears of anything else, let us know. We think it's coming together. So, all right. So that's it. You can still evict. There's no blanket moratorium on evictions. It's only for non-payment. It's only when the tenant signs that declaration. All right. So that's it. That's it for the moratorium stuff. I don't need to go into that anymore, but that CDC declaration, where our office in the last 6 months has received twice as many calls from apartment association members as we did for the years prior to that. So we know where the trends are, and that's been a hot topic. Next thing I want to talk about before we turn it over to John for some of the other programs. There are 3 changes to the magisterial district judge rules that I want you to know about. The first one is this change to Rule 503D. And let me pull my paper up here so I can read right from it. Where did I put it? sorry, there we go. There's a new affidavit that you have to sign. So when you file your complaint, there's an affidavit that you sign that says, as far as you know, the defendant is not currently in the military. This is a pretty common thing in like normal court or in divorce proceedings where, you know, someone may rush to get a default judgment or may rush to get a divorce when their spouse is overseas or when the defendant is overseas. This is less important for you guys, I think. I don't know how many of your tenants are in the military, they're not paying their rent, and you're trying to evict them for some reason, but everybody's gonna have to sign this affidavit now. And we'll send out a link to it. It's a one-page thing that just says, as far as I know, they're not in the military, and I've asked, or I've done a little bit of homework because the judge or the court wants to know where you came up with that information. So pretty important change there. If you're filing a complaint and the judge doesn't provide you this form, you need it. You don't want to create another way for a tenant to challenge this. So make sure as part of all of your evictions now, you're signing this affidavit. All right, kind of an easy one, not a huge deal, but again, you've got a just new form you got to fill out, and you're making some promises that you either know they're in the military, you know they're not in the military, or you're just not sure. All right. Next change to the rules. This is kind of fun because I don't know what you guys are going to do with this, but I can tell you what we've done with it in the past. Normally, you get your judgment for possession and you've got up to 120 days to execute on it. It's now 180 days. So you've got even more time to execute on your judgment. I think a lot of landlords are going to look at this and say, well, I got my order for possession, like get these people out of there, right? We've used this in instances where the tenant threatens an appeal, or maybe they have done something where they're able to fix it or cure it. So we've had some tenants that had to pay for damages. Well, as long as they paid the damages, we would not file for our possession for 119 days. We've used it in other instances too, but it's been a good way to settle some cases at the district judge level. And surprisingly, we've been successful with getting the attorneys from Northwestern Legal Services to sign settlement agreements on these things. So we'll get our order for possession and we'll sign a settlement agreement saying we won't execute on it for 119 days. But now you've got 180. So a little more flexibility there. It is a temporary thing right now, but I think there is some discussion to make it a permanent thing. So another change to know about. And then the last one, this is going to create some headaches for you guys. This is a really good example of politicians having good intentions and having no clue how the real world works. So there is a new affidavit that your tenant can sign called a domestic violence affidavit. And your tenant, let me find it. Your tenant signs an affidavit. They swear under oath, get it notarized, that he or she is a victim of domestic violence. They have to name the perpetrator of the domestic violence. And then they have to say if there's a PFA or not. It doesn't matter if there is, but I think it would help their case if there was. And basically, if they file this affidavit, they've got a longer period of time to appeal the eviction. So if you get your judgment from the district judge and someone signs this domestic violence affidavit, your timeline is now extended until you can get possession. I think, much like the CDC declaration, and listen, I don't want to sound unsympathetic to victims of domestic violence. I know it's a huge deal, but I've seen a lot of PFAs get filed all over the state for reasons not related to actual violence or actual abuse. We see them get used to play games, frankly. And it's not all the time, but it's a commonly used tool, especially in custody disputes and things like that. So this could be a way that your evictions get delayed a little bit. The problem is, one of the problems is the affidavit just says, I am a victim of domestic violence. It doesn't say that the violence happened within the last 30 days or 365 days. It just says, I'm a victim, period. So there's no timeline on there. There doesn't need to be a PFA filed. The affidavit says the court may consider the PFA filings or other evidence. So if someone goes in with this affidavit to delay the eviction. Maybe the judge is going to have a hearing on it or something like that. I don't know. This came out, I think, and Mike Micsky will correct me if I'm wrong, I think this was January 21st. So this is brand new, which is part of the reason that we don't know anything about it. The good news is I don't think any tenants know anything about it right now. I'm sure SafeNet does. I'm sure when there's an actual abuse or domestic violence situation, or even the police will know about it. But once word gets out that this is another tool that tenants can use to delay evictions, y'all know what's going to happen without me trying to sound too unsympathetic. All right, so those are our changes to the rules. So now let me shut off my screen sharing here, and here we go. I'll turn it over to John to talk about other recent changes.
Adam, thank you very much. Everybody can hear me, I hope. Yeah,
yep.
Thank you. Before I get on to a new topic, I had a couple questions I wanted to ask you, Adam. With regard to the challenge process that you developed, you mentioned that you went through the president judge in Erie County. Has anything been done in Crawford and Warren County? Because we have members in both those other counties too. Oh, you're muted. Adam, you're muted.
Yep, I got you. I was looking for Micsky's video so I could bring him on because he does more of this than I do.
Okay.
So it does exist in other counties. I don't know Warren and Crawford specifically off the top of my head. But this was the process that we're using here is very similar to a process in, I don't even remember what county it was. So like a lot of these things, the rules are all over the board, and it's a little different everywhere. Mike, do you know anything about Crawford or Warren with these?
There's not a similar thing in either one of them.
Okay.
Okay. Well, I just say, you know, if you're one of our members that has rental units in Warren or Crawford County, obviously the vast majority of our members are, you know, from Erie County, but we do have a sizable membership there. We may have to invent something for them too. So,
yeah, Mike, we haven't seen it at the district judge level in Crawford County, but we have at the Court of Common Pleas. And honestly, I think that's a different game. I think.
Well, you have a lawyer there, you know.
Okay, thank you. I was going to say it, but yeah, there's judges at the Court of Common Pleas treat these differently from the magisterial district judges. So we haven't seen any at the MDJ level in Crawford County or Warren County. And honestly, I don't think we've gotten any calls about it. I think it's all been Erie County on this.
Crawford. I had an eviction in Meadville. I evicted a tenant in Meadville last November.
Okay. Yeah, we've seen evictions go through, but as far as the CDC thing, we haven't seen anything on the declarations as far as an official process to challenge it down there in the lower courts.
Okay, I just wondered. And the only other thing I had, the Rule 503D affidavit, you would get that from the district justice office, right?
Is that the
form?
That's the service member one.
That's a service member one. Yeah, it's available on the PA Court's website, and the judge should have it. Where did we just filed an eviction somewhere outside of Pittsburgh, Mike? Where did we use this form, or did the judge have
the one
that?
off the PA Court's website.
Okay.
Okay. It might be something that we want to put on the Apartment Association website so the members can just download it conveniently, you know, make a note of that. All right. Well, thank you. Thank you, Adam. I wanted to talk a little bit about a recent legislation. Actually, it was Pennsylvania Act 1 of 2021, which was signed into law on, I believe, February the 5th by Governor Wolf. And this was a redo of the emergency rent relief program that we had last year. But last year's program was a dismal failure. I don't know if any landlords in our organization were involved with that, but it was it was based upon, I think, $150 million of funding that came from the CARES Act that passed in the fall of 2020. And it was earmarked for rent relief. And the Pennsylvania legislature, set this thing up, and the Pennsylvania Housing Finance Agency was administrating it. But it was a disaster because although well-intentioned, the rules and regulations and the red tape that they put into the program basically made it non-functional in like 80% of the cases. They required a landlord and a tenant to each separately make an application, which somehow had to cross paths somewhere. They put the Pennsylvania Housing Finance Agency in charge, which is basically like a mortgage lender whose job is to make sure that nobody gets the money unless every I is dotted and T is crossed. And when they're done with that, they make sure that the J's are dotted and the 7s are crossed too. So their whole philosophy in that agency is to prevent any money from going out unless people qualify, instead of an agency that is there for the purpose of helping people in need. So that was, I think psychologically, that was one of the problems. There was also a $750 rent cap per month, which in many parts of the state was even below the median rent for a 1-bedroom unfurnished apartment. And they also required the landlords to accept it in full payment of the full rent. And of course, if it didn't cover the rent, many landlords just didn't want to participate. And if the landlords didn't participate, no funding would go forth to the thing. So also, some tenants weren't eligible because they weren't yet behind on rent. They just recognized that they had a problem. They made an application, but the program wouldn't fund them if they weren't already behind, or if the landlords wouldn't participate. In addition, many of the applications arrived incomplete. They didn't have all the documentation enclosed. And in fact, it was really, in many cases, impossible for the tenants to get the documentations that they needed in order to prove that they qualified for the funding. They needed to prove that they had filed for unemployment since March 1st of 2020, or have lost at least 30% of their income since that point, which means they had to go back and find all their pay slips and everything from the previous March, which many of them had already tossed, or their companies had closed because of the pandemic, and so they couldn't contact anybody to get the paperwork. Anyway, many of the hardest hit industries were things like restaurants, where they really didn't have a lot of formal, paperwork to document wages and things. So anyway, there were a lot of red tape issues. And as a result of that, by the end of the program, any money that wasn't spent had to be returned.
But if you don't want to,
Excuse me, somebody have their mic on? I'm hearing something. If the money hadn't been spent by, I think it was September or something, it had to be returned to the state, because the state was required by a certain date. Anything wasn't spent had to go back to the federal government. They ended up, of the $150 million, they had to return $96 million to the state. That's how horrible that program was administrated. And the state rather than having to return it to the federal government, they used it to pay salaries in the state prison system. So that's what happened to rent relief last year, because the regulations and the rules for implementing the program just were done like destined for failure. Now we have a new CARES program, which was enacted in December, and then the state passed through the legislature in January, and on February 5th, the governor signed this Act 1, and it gives Pennsylvania, I believe, $852 million to be divided up, throughout all the counties of Pennsylvania. And those counties that have at least 200,000 population are able to administer their own program. And although it's under the supervision of the Pennsylvania Department of Human Services now, not the Pennsylvania Housing Finance Organization. So these are people that deal with poor people, and they're trying to help people. So I think it's a much better administration. Erie County was one of the counties that is going to be receiving direct money from the state. The Department of Human Services is developing a standard application, which will be used throughout the state. So they still have some administrative duties here to overlook or oversight duties, but within Erie County itself will be administrating the program. And I spoke with the administrator of the Erie County Department of Human Services the other day, and I asked her what was going on, and they said that they still haven't set anything up, so she couldn't give me any details on exactly how it would work. And I think that the Pennsylvania Department of Human Services hasn't even created the application yet, but they are working on that. So we expect to see that shortly. But let me give you some of the differences between the two programs, just to give you an idea of what of how they've tried to fix things. First of all, the administration is through the DHS, the Department of Human Services, and the larger counties are going to administrate their own under their supervision. But the smaller counties like Warren and Crawford are going to be administered by the State Department of Human Services. The assistance cap, the maximum amount of $750 per month, is gone. They don't have a hard and fast amount. It has to do with what the prevailing rents are within the jurisdiction that the application comes in. So that's more flexible. Under the old program, the tenants had to document 30% income loss since 3/1 of 2020. Under the new program, they are allowed to self-certify that. Basically just swear, under oath that that's what happened. And, yes, there will be some people that lie probably, but you know what the penalties are for perjury. And if they ever, anybody ever lied so much that a lot of money was lost, I'm sure they'd go after them. But as a practical matter, you just can't get all the documentation you would need. The landlord participation is not required under this system, although it is certainly in the landlord's interest to cooperate. There's a place for the landlord to sign the application along with the tenant. And if the landlord wants to get the check directly, the landlord has to participate. But if the landlord says, I'm not participating in that, then the tenant can apply and the tenant will get the check and they have to promise to give it to the landlord, which they may or may not do. You know how that works. All right. The duration of the assistance under the old program was a maximum of 6 months. Under the new program, it's a maximum of 12 months. And in some cases, I'm not sure exactly what that means because I haven't read all the regulations, but in some cases up to 15 months. I think maybe they're going back further a little bit in the past, another 3 months or something. So I have high hopes that this particular program will in fact provide real relief. I'm anxious to see what the application looks like and what the process is. If you had a problem with the last program, don't overlook this program because, you know, now, and the tenant doesn't have to initiate it. The landlord can, you know, can inform their tenant that's having a problem paying or whatever, that, yeah, let's work together on this. Because, you know, if you can keep a tenant and get your money, I mean, if you evict them, who's going to rent the property from you anyway? I mean, there, you know, it's a tough market out there anyway. So I think this is something that would definitely help. And that's really all I had to say about that. If you have any questions, we can address them at the Q&A.
So I think what we can do, John, is when more information comes out on that, we'll just share it with the membership as we've always done. But
it will be public. Any new information will be published in the PROA monthly update, which we send out each month. I hope everybody is getting that and reading it. It's we tried to the old newsletter that PROA used to have several years ago was boring as heck. And it was like 14 pages long, and all it was a list of bills that were going through the legislature. And I just told them, listen, it's not worth my effort to continue to type these things up because nobody reads this. What we really need to have is like a 1-page back and front or 2-page little write-up of the things that really matter, and do it in plain English so that the members can understand what the most important things are that are going on in the state government. And that's what that publication is. And I'm real happy to see that that's coming out now.
Yeah, I think the other thing on that is, you know, like you mentioned, it's important for landlords to be aware of it. We actually, our firm didn't deal a lot with the first round of it because I think most landlords that got into the program had luck with it, and we only hear when there are problems. So I think that's probably a good thing. But the numbers I was looking at this morning, Erie County has only recovered 40% of the jobs that were lost from the beginning of the pandemic. So all those bars and restaurants and other places that were closed, or the employees that were laid off, we've only brought 40% of those jobs back. And, you know, for those of you who are up on this stuff, the businesses were able to get their EIDL loans. They were able to get their first round PPP loans. We're in the middle of, or at the beginning of PPP round 2 right now. And if those funds run out, I think that those programs are the duct tape that are holding a lot of businesses together right now. I'm usually the optimistic guy, but we haven't seen the bottom of the market because of the pandemic yet. So I think you want to be aware of a program like this that's got money available. And I think you want to be familiar with the form so that when the time comes, you can jump.
Yeah,
on.
I see that Sandy wrote everyone a note that Crawford County does have the forms from DHS. They probably got them because that's one of the counties that isn't doing it themselves. It's coming directly from DHS. Sandy, if you have a chance and you could send that to me, I would appreciate it at johnb@velocity.net. So, because I haven't seen the form yet. I guess that's about it on that.
Great. Is there, I think that was the only topic that you and I talked about you covering. Was there anything else that you wanted to mention? Or?
Well, just any general thing. Oh, yeah, there are a couple things that are going on. one of the things that has kind of taken hold in the city of Philadelphia and is being now pushed to other places, and I don't know if anything's happened in Allegheny County yet. That would probably be the first place they would try it, is this rent to prevent eviction through rent mediation program. And I think right now it's a voluntary program where you can, before you file an eviction action, you can ask for mediation, and you get a mediator to kind of, inform both the landlord and the tenant what funding sources might be available, like this, CARES program money, can work out, payment plans and things like that. I mean, it's a program that slows the eviction process down, which obviously landlords don't like. But it also has the possibility that maybe the landlord might be able to collect some money that he wouldn't otherwise collect just by filing an eviction action, especially if neither the landlord or the tenant know about CARES funds and other things that might be available to help. So, I have kind of mixed feelings about it. Mostly I'm kind of negative. But the thing that people are starting to push is to make this a mandatory part of the eviction process in Pennsylvania. And I don't think that our state association is too happy with that. But anyway, I did send out an additional page on the PROA monthly update. If you downloaded your copy immediately when you got the notice, you didn't get the final page. So go back and download it again. Now you'll get the final page. There's an article on this eviction mediation program. How it works in Philadelphia. It's done by the Pennsylvania Housing Alliance, which is basically a tenant organization, but they also work with landlords, and sometimes PROA works with them on mutually advantageous things that are just good for the industry, basically for everybody. But it explains how that program works, just to inform our PROA members, what it is. We're not taking a stand on it because no legislation has been introduced, but we can just tell you that there's a lot of chatter out there about people trying to push this through the legislature to make it a mandatory thing. So we ought to at least all know what it's all about. And I'll be happy to answer any general landlording questions that people may have, or lease issues or whatever, as I'm sure Adam will also.
Yep. Cool. Well, thanks, John. So that concludes our segment of the presentation on pandemic related stuff. There are a couple other areas where we're seeing very common questions, very avoidable, but frequently arising problems. So the first one we want to talk about is fair housing in general, and in particular how it relates to assistance animals. Mike, you should be able to share. So I'm having attorney Mike Micsky talk about this section because honestly, I don't know anything about it. It's way too complex. It's way too nuanced. And it's just easier to have him know it instead of me. And I said this during the annual meeting, we were working on updating the packet for the apartment association. It's now updated. It's just sitting on my desk to finalize the review because there were some pretty significant changes made to it, I think about a year ago now, if I'm not mistaken. So we're going to send out a new packet on assistance animals or service animals or whatever you want to call them. So I'm going to turn it over to attorney Mike Micsky. He's been with our office for, I don't know, 6 months full-time, little part-time stuff before that. He's been a good fit for us because when he was down in Pittsburgh, was it a clinic that you did in law school as part of this like mediation process?
I did the, in my spare time, I did the landlord tenant mediation. through that pilot program that they instituted a year and a half ago, 2 years ago.
Yeah. So you were involved in your spare time when you weren't dealing with your
for
3
that.
children. Okay. Cool.
Well,
All right.
I only had one then, so.
Yeah. All right. All right. No comment. Good. So yeah, you should be able to screen share if you've got your slides on the fair housing and assistance animals stuff. And I'm going to mute myself.
All right, let me see. Can you
Yep.
see my screen now? I can't see you anymore, so.
Yeah, we can see it fine. Thanks, Mike.
Okay, great. So let's, Adam already kind of did the introduction. That's the reason why he's not doing this slide, because there is a difference between a service animal and assistance animal. He's not doing this presentation, so don't listen to him. We are going to focus on assistance animals, specifically under the Fair Housing Act. Service animals have a distinct category all their own, but they're governed by the Americans with Disabilities Act. And the guidance that Adam mentioned from early last year was really put out to eliminate the ambiguity between, there were support animals, there were emotional support animals, there were service animals, there were assistance animals, there were all kinds of terminology. And so what the guidance really did was simplify it. Now there's really only assistance animals under the FHA, which stands for Fair Housing Act. But I think it's helpful that we talk a little bit about what the Fair Housing Act is. And if you care about where it's found, it can be found in the US Code at those sections. But really, it all stemmed from the Civil Rights Acts passed in 1968. And it's been amended several times over the decades. One of the important things to keep in mind is the overarching goal of these acts is not to make the landlords hassle the landlords, which is what our involvement in it tends to be. It tends to be viewed as a hassle to the landlords for various reasons, and sometimes for good reasons. It's viewed that way. But the goal is to make sure that every American has equal access to the housing opportunities of their choice, free from discrimination for factors beyond their control. And that's in both the securing housing stage as well as the occupancy of the housing unit, use and enjoyment, maintenance, those types of things. And really for assistance animals, it can arise in the application process, but the majority of calls we get, frankly, is when a tenant has an assistance animal or asks for an assistance animal in the middle of their lease, and where it causes the most consternation for a landlord. Just a quick overview of what the categories are, because everyone has a general idea of the quick legal language said at the end of a commercial. If you think about it that way, we don't discriminate on the following things, but it is really important to take a moment to at least highlight what they are. And federally, there are 7 categories: race, color, national origin, sex, religion, familial status, and what the statute calls handicap, but what everyone refers to as disability, just to be politically correct. That disability is the commonly accepted terminology in courts and just generally when talking or presenting on the topic. An important note is it's illegal to discriminate based on actual status, protected status, and it's also illegal to discriminate based on what you think a person's status is. For instance, if you think somebody has a disability and you try to discriminate against them and it turns out you're wrong, you're still guilty of violating the Fair Housing Act.
So where I think we've also seen this, Mike, is there are organizations out there whose one of their primary purposes is catching landlords getting this wrong. They actually get paid to test this. And an organization will, the Erie County Human Relations Commission has done it. Southwestern Pennsylvania Legal Services has done it. They'll send an application to a landlord or 2 applications to a landlord with nearly identical qualifications. But one application will come from John Smith and the other application with nearly identical qualifications will come from someone with a name that sounds like a traditional African American name or sounds like a name from the Middle East. And if the landlord follows up on the one application, the John Smith application, and not the other, there's an allegation that you've attempted to discriminate based on perceived race or perceived national origin. So there are traps being set out there on this stuff, which is why we wanted to talk about all of the categories before we jump into the animal portion.
Absolutely. And those are what's referred to as testing agencies. And we'll get into it a little bit later. We'll touch on it whenever we talk about ways that this is enforced. But that's an excellent segue, I guess, into the next step, how we can go about to try to avoid that trap. But before we get there, I do want to point out just quickly that Pennsylvania has their own version of the FHA. It's called the Pennsylvania Human Relations Act, and it adds age over 40 for housing purposes, ancestry, and pregnancy to the protected classes. And then, as I'm sure most of you or some of you at least are aware, Erie County has their own, the Erie County Human Relations Commission ordinance, and it adds 6 more categories: ancestry, age, gender identity, sexual orientation, source of income, and criminal history if you ask for it at the time of application. You cannot ask for it at the time of application to protected classes. So it's important to note that while everyone talks about the federal status, protected statuses, there are state and local protected statuses that you need to be aware of as well. It just depends on who actually does the enforcement. So skipping over the ones not related to assistance animals, let's just jump right into disability. As I mentioned, it's defined as handicapped under the language of the Fair Housing Act. And it means a physical or mental impairment which substantially limits one or more of a person's major life activities. Adam mentioned earlier about, a lot of legal language, it's all in one place when he was talking about the CDC declaration. In this first bullet point, it really has a lot of important points there. It needs to be a physical or mental impairment. It needs to substantially limit, which means it can't just be a minor burden. It needs to substantially limit one or more of a major life activity. That may be brushing your teeth or driving or putting your clothes on, but it's not some minor things like, being able to change the television station. The person could have a record of being an impairment, or you could even just think that they have an impairment. There is a carve out to this that it does not include illegal use of a controlled substance. Now, typically when you talk about non-discrimination under the Fair Housing Act, you want to make sure you treat everyone equally. And that's when if you think back to what Adam mentioned, 2 identical applications with just a different name that could be based on race or where they're from. That's the generic treat everyone equally maxim under the Fair Housing Act. However, when it comes to disability, there's actually a second requirement, and it's actually the exact opposite. You need to take the person with the disability in the situation that you find them, and you need to evaluate every reasonable accommodation or reasonable modification request on a case-by-case basis. So it's a little bit different in that matter. Reasonable accommodation, it boils down to a tenant wants to not have to follow an existing rule or requirement that the landlord has to be able to fully enjoy their property. Whereas a reasonable modification is a requested physical change to a structure that would allow a tenant to enjoy the rental property. So that's a slight differentiation there. And it really comes down to whether it's a request to change a policy or a request to physically change a building or a common area. This is one of the most litigated, frankly, and complicated aspects of fair housing law, taking it aside from the assistance animal prospect or assistance animal part of it.
So when you say most litigated, this is the number one reason landlords get sued, right? I mean, that's what you really mean by that.
Yeah, that's exactly what I mean by that. Now, I don't want to sound scary, but make it scary, but it is the part where landlords get sued the most. So the best thing you can do is ensure your company has a formal policy. And when I mean a formal policy, I mean a written out policy and step-by-step procedure on how your company will handle a request for a reasonable accommodation or a request for a reasonable modification. You need to set a decision maker within the company. If it's just you, then it's easy. I mean, if you're a single member LLC and you own 4 properties, it's going to be you. But formally set the decision maker and identify who will make a final decision. If you have rental agents and they're the first step, consider adding an appeal process to a final decision maker. But no matter what, follow your policy. Make sure you document everything. And by document, I don't just mean shooting an email or taking a picture of it. Formally document it, put it in their file, make copies of it, give the copies to the tenant. Because one of the best things you can do to avoid potential litigation is to eliminate liability should litigation arise, is to show that you kept the tenant engaged in the decision-making process through what is a legal term of art called the interactive process, where if they ask for something, you come up with and it's not something that's feasible or something you want to entertain, that's not reasonable, try to think of other ways that you can make the same decision to get to the same outcome, but with a different process to get there. And then retain everything. Keep all of your documentation and then evidence of all your outcomes, whether you granted it or didn't grant it, for at least 3 years after the tenant leaves.
So I want to jump in on that interactive process thing, because that we deal with this a lot on the employment side too. These federal organizations or any of these organizations want to see you having a dialogue with your tenant. If a tenant comes and says, I need the following accommodation, right? Could be an animal, could be something else. Don't say no. Don't say we don't do that. You have to listen to them. You may want to talk to an attorney before you respond to them. But this is supposed to be a conversation. This is supposed to be reaching the point where there's an accommodation that isn't outrageously expensive for you, but that will allow you to accommodate them where you aren't discriminating against anybody. So blanket statements, blanket policies on this are a really bad idea. The interactive process, it's supposed to be a dialogue. You're supposed to be working together. So tread very, very carefully there if someone asks for an accommodation.
And so moving into how what this has to do with an assistance animal, I've already alluded to it, or maybe I've already actually just outright said it. A request for an assistance animal is a request by a tenant for a reasonable accommodation from your policy, either a no pets policy, either you can have a pet, but it's going to cost you money, or even we allow pets but no Rottweilers policy, specifically due to a disability. Any type of request for an assistance animal will fall under the Fair Housing Act. So what should you do? Well, there is, if you want to try to do it alone, which again, we don't recommend, you're on this call, so you have the apartment association, so you can call them as a first line of defense to help you walk through it, or at least guide you to the packet that Adam mentioned that will be circulating. Or you can go to this document yourself to try to read through it. The Housing and Urban Development Department from the federal government updated the guidance a little over a year ago to streamline the process, and they tried to give a step-by-step process by how to go about either approving or denying a request for an assistance animal. The link is here. But frankly, it's 19 pages of traps. And it's not that they were trying to trick landlords into doing it, but everything is reasonable and everything is subjective and everything needs to be on a case-by-case basis. So there is no blanket statement that you can make in any situation there's no one-size-fits-all approach to assistance animal policy. This is what the front page of the document looks like. This is the best flow chart that we could find, quite frankly, that tries to boil down the 19 pages of the guidance into a way for a landlord to try to follow along. But even this isn't enough to help, frankly, to give you an answer one way or the other. As you can see, there's really two tracks because as I mentioned earlier, there is the ADA service animal requirement, but that's really easy to, frankly, it's is the animal a dog? Yes. If it's not a dog, it's not a service animal. Only a dog can be a service animal under the ADA. Is the dog is it readily apparent that the dog is trained to do work? i.e., is the dog leading a blind person? Is the dog helping somebody with a wheelchair? If yes, you have to allow them. If no, you can ask the tenant, is the animal required because of a disability? If they say yes, you can say, what work has the dog been trained to do? If they give any answer, opening doors, then it's a service animal. And so it's really easy to move past that stage. If it is a dog, or if it is not a dog, the dog's not readily available, it doesn't meet the service animal criteria, it still could be an assistance animal. And this is where the traps start to occur for landlords, because the guidance allows some discretion on the basis on the landlord's discretion to make the decisions. And oftentimes landlords just say, well, that just means I can say no. But you still need to go through a thorough analysis of whether or not the animal is acceptable, or the person itself has followed your policy to request a reasonable accommodation under the Fair Housing Act. So the first step really is, has the tenant actually asked you for a reasonable accommodation? And oftentimes landlords say, well, they never came out and said, hey, I have an assistance animal, I would like an accommodation. If they beat around the bush, you're expected to know that they're asking for a reasonable accommodation. If you think they may be, the best thing you can do is to ask them, are you asking for a reasonable accommodation? If they answer yes, direct them to your policy. If you're a single owner LLC, then you'll have the policy at your hands and you can go get it for them from your office, or email it to them, or hand it to them. But if you have rental agents, train them to listen to see what the tenant is actually asking about. And then if the tenant specifically asks them, don't let them answer off the cuff like Adam mentioned. Make them go to the office to formally start the process.
Mike, what happens in the situation where a landlord goes to evict someone for violating the pet policy, and the person says, well, this isn't a pet, this is an assistance animal or a support animal? Then what does the landlord do?
Well, thanks for jumping to the hardest option.
I need you to hurry up, man. It's late at night. We all want to eat dinner, see our kids.
My kids don't go to bed at 8, so I'm trying to drag this out. There were differences of opinions here. If it's a situation where you're already in court and the landlord raises the issue, or the tenant raises the issue either in front of the magistrate, or you filed for eviction and then they come to you later, quite frankly, you need to start the process, and you need to start going through these steps. It's not an automatic pause, but you still should reset and consider, frankly, waiving your complaint until you can, or not moving forward with your complaint, or withdrawing your complaint until you go through these steps to make the determination. Because if you don't, and the eviction continues, not only will the tenant likely appeal in the normal course of appealing, but then they have a direct cause of action that HUD will be more likely to get involved quicker for failing to provide a reasonable accommodation at that point. So really what it comes down to is, if there's a request, you need to make the determination yourself as the landlord or the decision maker. Does the person have an observable disability, or do you already know about the disability? like, did they tell you, did they happen to mention it in passing? Do you have evidence that, they get SSI or some other type of housing funding related to a disability? If the answer is yes, then you can ask them or request documentation that shows that the animal is specifically related to that disability. And if it is, then you have to accept it. If it's a traditionally commonly kept animal, like a dog, cat, rabbit, gerbil, fish, ferret, anything that's really a traditionally domesticated animal, that's not a monkey or a bird or a kangaroo, or no, a bird would be considered commonly kept, but a miniature horse may or may not be. That's another issue altogether that we don't have time for. But exotic pets like a boa constrictor may be not considered an emotional support animal. If you can't tell whether or not they have a disability, or you don't know of a disability, you're entitled to ask for information that shows they have a disability. Like I mentioned before, they can give you SSI information that shows they're getting disability insurance through that. Any other type of disability, like if they have a bus pass that shows they get free bus passes because of a disability. Housing vouchers, or and what our assistance animal packet suggests but doesn't require is a note from a healthcare professional that shows they have a disability. And what you're allowed to ask for is really a letter from a doctor that knows them, or any type of healthcare professional that knows them or is treating them, that needs to be general as to what the disability is. They can say they have an emotional disability that requires an animal, but it needs to be specific as to what the assistance animal is, as well as what benefit the person derives from the assistance animal. For instance, they're afraid of thunderstorms and they will not be able to function in the event a thunderstorm happens in the middle of the night. They have an emotional support cat that gets them through it by petting the cat. If that note comes from a doctor, that's likely sufficient documentation to support that the person has a disability, and that the pet, or not pet, the assistance animal is used for that disability. Another I want to say one of the most helpful things that the guidance did was actually call out tags, emotional support tags bought on the internet, documentation directly from the internet, and says that's not proof enough of an emotional support animal, but it can be proof taken into context. So just because somebody gives you a doctor's note from the internet, don't automatically discount it and use that as your basis, because you have to do an investigation, or you have to use your reasonable knowledge to determine and review the letter to see if it's somebody that is actually treating them remotely, or somebody that has knowledge of the person, or if it's a form that's just bought off the internet because you've seen that same form advertised on Amazon, or that same documentation advertised on Amazon.
So that was a good thing. That was a good thing that changed in this a year ago. Is it used to be you kind of had to accept those, and the only repercussions were criminal repercussions. But now the landlord can use judgment.
Right.
But I think the important takeaway there is you don't have to blanket accept them, but you also can't blanket reject them. It's case by case. Consider everything that's in front of you before making the decision.
Absolutely. And one of the other things, the biggest takeaway here is and the question we get most often asked is, can I deny this? Basically, what it comes down to is, if it's not somebody who has a readily discernible disability, and it's not a dog or a cat that clearly you know about, or that you clearly you have the suspicion or the strong inclination that it actually is something. you're allowed to ask for reasonable documentation to support their request. If the disability is not discernible, you can ask for documentation to support the disability. At the same time, you can ask for information that supports the fact that the animal is necessary for the disability. And then it comes down to whether or not that information is reasonably supporting what they're saying. So I'm using the word reasonable a lot here, and oftentimes a landlord just says, I think they're lying because they asked in the middle of the lease. The timing doesn't matter, and even if the person asks after you filed the complaint, in Adam's scenario, you need to go through these steps to protect yourself from even if you're successful in the eviction, you need to go through these steps to protect yourself from a federal charge being brought against you, at least through the housing and urban development process. So the best practices here are have a written policy and consistently follow them, because if you are sued, they will ask for your policies and proof of all of the recent times, all the times in the last X amount of years that you've followed or deviated from that policy. Document everything. Keep the purpose of the Fair Housing Act in mind when interacting with tenants, whether they're prospective or current tenants. And if it is a person requesting a reasonable accommodation, keep in mind that you're supposed to treat them individually to review their reasonable accommodation request on a case-by-case basis. Train everyone who will talk to tenants on the FHA. And then again, this is one of the times, especially when it comes to assistance animals, where it would help to call an attorney to at least talk through what you want to do here. If just to talk through what your process should be. If you don't have a process, consider, drafting one in conjunction with an attorney. So you have the protection of formal documentation you can fall back on should a tenant decide to sue you. So what happens if you deny the tenant? How is the FHA enforced? It's either enforced through a private complaint, i.e. the tenant sues you, a testing agency sues you, as Adam alluded to earlier, or the government takes action themselves after a private complaint or a third-party complaint. And just because HUD denies or doesn't want to follow through with a complaint, they have the right and often do refer their cases to the Pennsylvania Human Relations Commission, especially if someone alleges more than one cause of action. So if you have an elderly tenant who wants to sue you based on the fact that you didn't allow them to have an emotional support rabbit, and they also want to sue you because they want to claim that you discriminated against them because they were over 40. HUD's going to always refer that to the Pennsylvania Human Relations Commission because Pennsylvania has a cause of action for age. HUD doesn't. So keep in mind that just because the one cause of action may be federal, the other one, there may be additional causes that refer to state action as well.
Mike, could I ask or mention something?
Yeah, absolutely.
Just briefly. A couple of years ago, I recall PROA was working on a law that we got passed through the state legislature, and the governor signed it into law. I don't know what the citation of the act is at this point, but it had to do with these emotional support animals, and it was to put in Pennsylvania law that a landlord didn't have to accept something that was purchased over the internet where they get a doctor's letter and, a collar and I am a support animal, jacket that the animal wears, which were just rampant. But that it had to be a professional that actually was treating the individual or had examined them. And so I think that's something that's been very, very helpful. You don't have to accept it if it comes off the internet. But as you said, just because it comes off the internet, I mean, there is such a thing as virtual treatment, that people can be far away from each other and still get treatment. But typically these people that sell it over the internet, they don't even bother to ever talk to the client, or they might just call them up and say, "Hi, I'm Dr. Smith, and have a nice day." You know, if that's the only thing that they've had as far as knowledge of this thing, you don't have to accept it according to Pennsylvania law. I don't know if the federal law, you know, supersedes that, but
So it's, yeah, I'm always apprehensive to say you don't have to accept that, because what 68 people are hearing right now is, I'm not going to accept it, right?
Yeah.
And it's dangerous. We get so many, and I'm seeing the questions come in the chat, and some are to everyone and some are to me. People want black and white answers on this. It ain't gonna happen. That we have to dig deep into this. So someone says, "Oh, what? I'm a landlord. I have an allergy to, you know, cat hair, dog hair, whatever. Does that mean I can say no to this animal?" Well, not necessarily, right? You may have an obligation to have someone else do the maintenance on the property instead of you. Or, you know, how bad is your allergy? You know, there's a million things that we have to consider here that I'm never going to tell you, well, yeah, you have a super bad allergy to cat hair that, you know, you're going to go into shock if you walk into the building. That's not enough for me to tell you, you don't need that. You don't need to accept this animal. That's not enough for me to tell you that. We need to know more about it, right? Same thing on the insurance company restricting certain breeds of dogs. We're getting this one all the time. Your insurance company is breaking the law by saying that. And that's a huge issue that, you know, we're getting, like, people are yelling at us, well, that's my insurance company. Yeah, well, I'm the freaking lawyer, okay? So yeah, just because your insurance company doesn't allow it, you may need to find a new insurance company. Reasonable is the word of the day. Reasonable is the word that keeps us employed so often. Reasonable is not black and white. Reasonable is not, here's what you do in every situation. Reasonable is, what are the very important, very specific facts of your situation, and how do we apply them? And that's why this is such a struggle. That, you know, every time I see the question posted in one of the Facebook groups, it's like, anybody who's answering your question based on a 2-sentence fact pattern is giving you horrible advice, because they don't understand everything that goes into this. So, and again, like, I wish you guys had to pay me for every phone call that you make to our office, but you don't. But we're still telling you to call us because it's free and we're going to keep you out of trouble. So yeah, we're going to have the materials available on the website. Sure, you can go and find this flow chart from Utah, but keep in mind, this flow chart is a summary of 19 pages of landmines and other traps out there for you, right? So you can look at this, but this is not going to answer all your questions. This is not going to cover everything that's covered in the law. And it's also not going to draw on all kinds of outside experience with similar areas of the law, like employment law, to get advice on it, right? And the last thing is what we like to do. We like to issue opinion letters where we will put in writing on our fancy letterhead, yes, this is a good move and you can get away with it. That type of document can go a long way with some of these organizations. So, sorry, I had to rant a little bit on there, but I wish I could tell you I was dodging answering your questions, but the reality is, until we talk on the phone for 20 or 30 minutes, I don't have all the facts I need to give you an answer on this stuff. Sorry.
Well, the other point is that, you know, if it's something that's you know, just right a marginal decision, you're not quite sure what to do. You call Adam, he's not quite sure what to do. I guess what it really comes down to is sometimes maybe you got to say, well, what's the harm of letting this person have a cat? You know, if the other tenants complain that they can't have a cat, you can say, well, it's an emotional support animal. They've given me the documentation for it. Even though you might have a little inkling that maybe they bought that over the internet, but, you know, yeah, you can have some damage done by pets. I understand all that. But, you know, you can still hold the tenant responsible for damages caused by an emotional support animal. They still have to be responsible for the animals that they have. So sometimes you might need to just shrug your shoulder and say, well, yeah, I'm not 100% sure of this, but I'm going to allow it because I don't want to take any risks.
Yeah. So, and that kind of relates to this question that's in the chat about what if they don't meet your other criteria? I'm not going to answer this, but I'm going to tell you the things that I worry about when I hear questions like that. So the assumption in your question is that you have written criteria that you use to analyze your tenants. Many landlords do not, so there is a trap. But let's assume you have written criteria about 3 times income, whatever that means, credit score, et cetera, right? If you've got all of that documented, and the second assumption is you actually follow that with every application that you get, then the third assumption is, yes, this person was not otherwise qualified and they asked for an accommodation, then we could make a very good argument that you're not discriminating. You're following your policies. But 2 issues. 1, that may not stop you from getting sued, right? You may win the suit, but you'd rather avoid the lawsuit. My kids who need to go through through college would rather you get sued and you win the suit, but your kids would rather you not get sued. The other thing that we're assuming there is that your policies that are documented and that you follow consistently are not discriminatory in and of themselves. So I'm assuming you're not messing up the criminal background thing. I'm assuming that what seems like a neutral policy isn't in fact adversely affecting certain minority groups, and credit score may be one of those things, honestly. Then yes, with all of those assumptions being true, you don't have to let these people in if they also want an accommodation or a service animal or support animal or whatever on top of that. But that's like I've been in this office for 12 hours, I've run out of coffee, I need scotch, and I'm trying to give you as quick of an answer as possible on Zoom. Those are just the things that popped into my head that you can screw up with something like that. So the good start is, yes, criteria, written criteria that you follow consistently, but documented policy, like Mike said earlier, that's one of the keys to this.
So one of the, just to summarize a couple major points right there is you're never going to be able to prevent yourself from being sued if someone wants to sue you. And so having a policy, a formal written policy in place that you follow is the easiest way to get out of liability if you are sued. Another important distinction, and I've made the mistake myself on this call, I guess is the right way to phrase it. An emotional support or assistance animal is not a pet. Your insurance agency may have a prohibition on what kind of dog or what kind of pets your tenants may have, but if they are prohibited, if they drop you because you have a tenant with a disability that you went through the process set forth by HUD guidance to confirm that they do have a disability and that the animal is in fact an assistance animal, and they deny a request there, your tenant or you yourself may have a cause of action against that insurance carrier. Especially if there's a breed restriction on dogs. I see a question that came in directly to me. I just found out I could look at these and I had direct messages. So sorry, everyone. There is a distinction between what you allow in your pet. You can have a pet policy that says no Rottweilers. There's nothing discriminatory about that. But if a person with a Rottweiler that has that is an assistance animal comes to rent from you and they meet all of your other criteria, and that's the only reason you want to not rent to them is because they have a Rottweiler, then you can't. That would be discrimination in and of itself. And then the other direct message I see is a person who has on SSI does not provide a note from a doctor. If the federal government says you're disabled, then there's no reason why you should have to ask for a doctor's note as well. You just need to have reasonably supporting documentation, and I would consider the federal government saying you're disabled definitely reasonably sufficient information. To summarize, you can be sued by, I guess, to quickly run through these, you can be sued privately or you can be sued by a testing agency. The process is you'll get a complaint. They'll ask you for a ton of information. They'll ask you for all of your policies reasonably related to the discriminatory action. They'll ask you for copies of your leases, copies of everything similar that you've done in the last 3 to 5 years. Every time somebody's asked you for an assistance animal request, what are the outcomes been? And what were your policies or your processes to documentation that you supported your outcomes? The HUD investigator may ask you to try to settle. If there is no settlement, then there'll be a charge either against you, saying you did discriminate or a determination of no reasonable cause. Even if you win at the HUD level, you can be sued privately. And the fair testing, the testers can actually sue you directly. Northwest Pennsylvania Legal Services can sue you directly. And they step into the shoes of all the tenants that have been discriminated by your actions based on testing. So treat everyone who comes in that the same, that you're a tester. And if someone sends you, have formal policies in place that say, here's what you do. If here's your answers, your employees' answers to every type of question that may come in related to renting, how things are handled, who people are in your properties. If someone calls you to ask those questions, and they're likely a tester, but they don't have to ask those questions. They could just be simply mailing or emailing you applications, as Adam mentioned at the beginning of the call. And then if there is a charge against you, the government will then sue you directly. The Department of Justice will file a complaint either at the administrative law judge level, or you can request a federal trial. But then you're going to be responsible for damages at that point if you're found guilty.
So let's get through. You can stop sharing yours. I'm going to blast through the last couple topics I have, and then we'll open it up for all the Q&A. The other thing that we're seeing frequently on the fair housing stuff was discrimination based on familial status, and that becoming a problem for people who rent to students. So there are more landmines out there. So
Adam, one direct message that came in. You cannot charge for an assistance animal at all. You're allowed to have an addendum. It's our position that you're allowed to ask for an addendum that says this is the assistance animal you're allowed to have, and that's it. But what you cannot do is ask for your pet policy to be followed. You can't ask for a monthly pet fee. You cannot ask for a pet security deposit. It's as if that pet doesn't exist. Now, John was right. If that pet scratches the hell out of your carpet, if that cat scratches the hell out of your carpet, that's normal wear and tear that the tenant themselves is responsible for. So you can retain that from the security deposit that they paid during their lease as if there was no pet. But what you can't do is ask them for an additional $300 when they ask for an assistance animal. They are not a pet. They're essentially the same as a crutch, or a wheelchair. If you think of them that way, that's you can't charge somebody for having a wheelchair versus.
they're a super cute wheelchair, though. Look at that dog.
Oh yeah, for sure. You have way better slides than I do.
I know that. All right. Thanks, Mike.
Yep.
Okay, so we're back to the agenda. We've covered all the pandemic stuff. We're on the general landlording stuff, assistance animals. That was a really deep dive. That's a super complex topic, but we're seeing you guys screw it up all the time. So anytime that stuff comes up with like, again, I don't make any more money when you call for advice on this stuff. So just call us when it comes up. All right, I want to talk about two other topics that, again, I think this is really helpful advice for you guys. And if you could take this to the hundreds of landlords that aren't on this call, that would save me a lot of time too. Notice. I'm going to skip that. I'm going to go back to that one. You heard me talk a lot about the CDC moratorium, about evicting for reasons other than non-payment of rent, right? I want to give you some tips on giving notice to your tenants before you evict them. Because it blows my mind that we're seeing people screw this one up. But if you don't give notice to your tenant in compliance with the lease or the Landlord-Tenant Act, and you try and evict for reasons that you didn't include in your notice, the judge is probably not going to accept those. If you try to evict for reasons related to non-payment of rent and the moratorium issue comes up, you want to have reasons other than non-payment that you've included in there. And then most of you should also understand the pay and stay issues that are created with rent evictions versus non-rent evictions. So this is your lease, 2015 version of the apartment association lease. All right. I'm going to tell you what it says, or you can read it, but then I'm going to tell you what I think most people should be doing in these situations. So the first paragraph if the tenant breaks the lease for failing to pay rent, 5-day notice. Most of you are familiar with that, right? It tells you that you have to give it to them, or it needs to be posted. It needs to spell out how much they're going to pay you. And it says basically, you've got to pay or we're going to kick you out of here, right? The forms are available on the apartment association website. Most of you guys understand how to do that one. The second paragraph, though, this is the one that I really like, that if the tenant or the tenant's family or the tenant's guests break the lease for any other reason, you actually don't need to give them notice, okay? So in theory, if your tenant is there today and they're knocking a wall down, you could go in tomorrow and evict them without giving them any notice of that. That's what the lease says. In practice, I think it's a really good idea to give them notice to do that, unless there's some emergency or something like that. So if you've got to give 5 days notice for rent and 0 days notice for everything else, I think the best practice is this kitchen sink approach of include it all, give them the 5 days, at least if you can, and make sure that every possible reason you could evict them is included on there, right? I don't know why this has been such a challenge for a lot of landlords, but this section 29, this is your section. When we talked about the CDC moratorium earlier, I cited some other common sections of the lease that you can allege violations of, but your notice needs to spell out what spell out what section they violated and what they've done to violate it, right? So the rent one is easy. You agreed to pay rent, you didn't pay rent, slam dunk. But the other ones that, for example, if they violated the provision that the utilities need to be paid, then you need to say you violated this section that your utilities need to be paid, and you violated that when you didn't pay the electric bill or you didn't pay the gas or the water or whatever it is, right? You need to allege very specific facts in the notice. That's really all I want to talk about in the notice. I don't understand, like the forms are available, but as a practice, include as much as you possibly can in the notice. And who knows, maybe some miracle will happen. And in the 5 days that you give, the tenant fixes everything that you've said they've done wrong. But what you don't want to do is give the notice, wait your time, show up in front of a judge, and the judge says, well, you're evicting them for painting their walls pink, but you didn't give them notice that they weren't supposed to paint their walls pink, right? That's a stupid example, but you understand what I'm talking about. So that's all I want to talk about on the notice things, because we're seeing that a lot, that landlords are like struggling to come up with other lease violations. Read your lease, be familiar with it. You'll be able to find good reasons for the bad tenants. All right, last thing. We have made it quite a while, an hour and 45 minutes. And we've tried to give you as much help as possible. We've told you to call us for free advice. But now's the point where I try and sell you something. We are getting so many calls from landlords who buy property, and they've bought it from the prior landlord, and there's a deadbeat tenant there, and they want us to help evict the tenant. This is an entirely avoidable situation. If your closing attorney did an effective job, you would not be stuck with the deadbeat tenant. I can't believe, I can believe this because I understand how it works, but so many properties that get sold, the leases aren't up to date. The landlord doesn't know where the lease is. They haven't kept track of how much rent the tenants have paid. They have no clue what the security deposits were. And then we are getting calls after closing. We didn't do the closing. We're getting calls after closing saying, hey, this tenant hasn't paid rent in 8 months. Can you help me evict them? This is especially problematic during the pandemic when you got judges that aren't super stoked about evicting people as it is. So there are things that you can do to prevent these issues. And as much as I jump up and down and scream and yell and pound my fist on the table, no one listens to me. So if you're buying a rental property and you ask our firm to do your closing, we'll give you a 5% discount on the closing fees. I'm doing that because it's going to avoid 10 phone calls a month where we're trying to evict tenants that you could have avoided the problems with to begin with. All right. So if you're buying a property and you need the closing done, call us and we're going to make it so much more fun and so much more enjoyable, and avoid these very expensive headaches for you. Okay, so that's it. I made it an hour and 45 minutes. I spent 2 minutes trying to sell you something, but we did something like $30 million of closings last year in our office. We do a boatload of this type of work, and I think our expertise with the apartment association really helps with that. All right. So the apartment association sent an email about that on February 5th, but the subject line of the email was a letter from our lawyer, and I know nobody opens emails like that. So whatever. All right, so that's it. We got our new website, Rust Belt Legal. You've got our office phone number. But honestly, and I say this somewhat jokingly, when you have these questions, most of these questions, call the apartment association first. They deal with way more of these calls than we do. The run-of-the-mill stuff, they can handle without you having to talk to us. And you will never call our office and immediately speak with an attorney. The calls, we always schedule a time to call you back so that we're prepared and focused and have it in front of us. So you'll get faster answers from the apartment association, but then when they can't help you, you can call us and we can help you out. Zachariah asked me to put that up again, please. I don't know what you want me to put up, but I
think the last slide, Adam.
Yeah, so that's our website. I mean, you Google Adam Williams, Erie, Pennsylvania, and you'll find everything you need to know. Although, like, the 7th or 8th result is the Go Erie op-ed I once wrote, and it says something like, "We need to learn from failure, comma, Adam Williams," as if I'm the failure. But no, it was an op-ed where I said we need to learn from failure. Whatever. It was. I tried to sue the Times News once when they did that to me. All right,
Adam, I just wanted to mention something that happened a long time before you became our solicitor, but it used to be that we didn't have a solicitor, and I used to get the phone calls from people say, "What do I do?" And of course, half the time, you know, I'm not a lawyer, so I didn't really know, but I tried to give them as best advice as I could, which I probably shouldn't have. But anyway, I remember one time a guy called me up. He said, "I bought this really nice apartment house and everything else, but there's this one tenant in there that hasn't paid for 6 months, and I got to evict him." And when I went to evict him, he went in front of the judge and he says, "Oh, I did the previous landlord a big personal favor, and he told me I didn't have to pay rent for a year." And of course, the landlord had moved out of town, so they couldn't bring him in as a witness. So guess what?
Yeah.
So that's one of the, that can happen.
That's your free legal advice of the day. Don't barter for rent. Pay them for the work and have them pay you for rent. We're getting a lot of these ones. "Oh, it's a family friend and he's always..."
I don't think it was even true. I think the tenant lied, but you couldn't prove it.
Yeah. Yeah, so it's like I said, we track the calls that we get. We've been getting twice as many the last few months. So we have a pretty good process in place that someone will take a detailed message, they send the attorney the information, we schedule a time to call you back. Because honestly, if you called us and we had to answer these things as they came in, we always need to do some level of research before we respond to your calls. If it's complex enough that the apartment association staff doesn't know it off the top of their heads, honestly, we won't know it off the top of our heads. So we're finding that this is the way to give the best advice. We've got a really good system in place. We're actually improving that system so we get some follow-up emails and reminder emails out to you guys. So I think it's gone well pretty far so far. Most of the calls that come in are not emergencies that need to be dealt with right away. Obviously, if they are, we can handle that. But for most folks, we try and get you on the schedule as soon as we can. And now with both Mike and I answering the calls or answering the questions, we've been a little more responsive with it. So.
Are you going to send out the PowerPoint presentations to all the participants here? Or?
Yeah, so here's what we'll do. Mike and I will put our slides together in one document, and then we're recording the call too. So we'll send that. So we'll send all the materials out and all the relevant links and stuff like that. So it may take a little while, but we'll get everything out to everybody for sure. All right, what other questions do you guys have? I'm getting a ton of messages asking me for sample policies. If you want sample policies, find them on the internet, but do it at your own peril. The way it's like finding sample contracts, finding sample leases. Oh my God, the leases that people find on the internet. It's the way that you do things is different from how your landlord next door does things. So if I give you a sample policy, it may not be something that you like. It may not be something that you want to follow. So yeah, we don't generally do that. You can find examples out there and you can pull from them, but I would never just copy and paste a sample policy on something like that. So sorry, I don't really have one that you guys can follow. It's the same with your rules and regulations, right? The rules and regulations that you want to have for your units are going to be different from, the building next door. So
Yeah, Adam, I think that's a good point. If you publish rules and regulations, you're going to have a heck of a lot of easier time evicting somebody for non-payment of rent if you have published rules and regulations. If you don't have published, or you don't have rules that you've given to the tenant, you can't make them up. The judge is almost never going to let you just make up rules and then enforce them. But if you have a set list of rules and regulations like quiet hours that are in line with the applicable city ordinances, and they violate that, and that's a rule, there's your non-payment of rent issue that you can evict for.
So actually, let me show you guys this too, because this is one of my pet peeves every single year at this seminar. So let me share my screen. This is your lease. All right. So 2015 copyright date. If you've got the version that's the 1999 copyright date, update it with all your tenants with this one. But there's this section at the bottom of, don't worry, I'll find it. It's at the end. Here we go. Bottom of page 7. Landlord and tenant also agree as follows. I'm finding a lot of landlords that write a lot of really, really bad stuff in here. It conflicts with the rest of the lease. They make up completely illegal rules. But when you find yourself writing a bunch of things in here, tenants can't park on the grass. You have to use regular window coverings. You can't staple blankets up. When you find yourself writing a bunch of things like that in this section, those should be in your rules and regulations. They're easier to change. They can be much more thorough. And I don't know, it's just a good way to do it.
Adam, go to the section just above that where it says lead-based paint disclosure.
Yep.
Okay. If you have a set of rules and regulations for that particular building, or even generally for your operation, type those things up, print them up, make them nice and pretty, and call it rules and regulations number 75 or something, or give it a name, and put that as a title on top of it, and then write that name in this thing here, and then then take those rules and staple it to your lease, because that way anything you have here, the attachment of this lease, the attachments of this lease there's language in the first part of the lease that says anything that is named there becomes a part of the actual contract. And then of course you have to attach it, but by naming it there, that adds it to the actual deal. And then that is the best way to publish it. Now, if you have to make a change, let's say you have to change the hours of the quiet hours, or you have to change the laundry rules of the hours of the laundry room, you can make those changes. But what you need to do is you need to write a letter to all your tenants that are affected by the change, and you need to send it to them in writing. And then what you need to do is also staple that letter to your copy of the lease, so that you can prove that it was in fact disclosed to everybody in advance. Because like Adam said, don't go make up a rule and then go into court and say, oh, judge, I got this new rule. He's not going to listen to that.
So I disagree with one piece of what you said, John.
Okay,
I agree with all of it, except I don't like attaching the rules and regulations to the lease. I think that makes them harder to change. I think you would have a tenant that says, well, I signed the lease in January and these were the rules, and then I never signed a new lease in July when you changed the rules. So what gives you the right to do that when it's incorporated into the contract? And this is a very subtle legal distinction.
Adam,
if they're not incorporated in the contract, you got this paragraph 11, that just says the landlord can impose reasonable, there's that word again, rules and regs. They can be imposed or changed from time to time just by notifying the tenant in writing. So you're not changing the contract, but you're changing these reasonable rules and regulations. So I think by not attaching it actually makes it a little bit easier to do it. But I think this is an underutilized section of the lease that can be very protective of landlords if used properly. And again, I don't have a sample set of rules and regulations, but if you've been a landlord for any length of time and you've dealt with problem tenants, you have some ideas of what some of these rules should be in your head.
Hi, can I ask a question?
Sure.
So I recently had an issue with a 2-unit apartment, a top apartment and a bottom apartment, where, and this kind of goes along what you guys were saying with, quiet hours, where there was, people playing drums and TVs blaring at 2:30 in the morning, which obviously I know would be too late, but does are there any city ordinances or landlord tenant law that actually specify quiet hours? I mean, obviously 2:30 in the morning is too late, but is it 9 p.m., 10 p.m.? Can you elaborate a little bit more on that?
I'll make
I
a
could
stab
elaborate.
at it. I'll make a stab at it.
Yeah, go ahead.
I don't know if there's any like quiet hours for the city of Erie or whatever. I kind of doubt that there is. But all I can say is that any landlord that has a multi-tenant building has to be concerned about noise complaints. And if you aren't when you first buy the building, after a year, you will be concerned about it because you'll get noise complaints. You'll get complaints about somebody that I saw walking in the hallway that had no reason to be in that hallway at 2 a.m. And you'll have these kind of complaints. And you should put something in your rules and regulations about that. Now, if you have a single family unit, a house, there's no reason to have that sort of complaint unless you're really worried about the neighbors. And sometimes you are really worried about the neighbors. So all I can say is I don't think there is anything, from the law. If you think that you need to have something in your lease and you don't have it in your lease now's the time to write that letter to make that rule and regulation, which you have the right to do, promulgate it to the tenant. That means send it to them in a letter, make sure they have it, and then now you have it.
And we'll get back to the word reasonable again, right? You want your tenants to act reasonably, reasonable volume at reasonable times. That
Right.
gives
You can't say you can't ever play a drum, but.
Well, maybe you want to. Maybe you don't want them playing the drums at 2 o'clock on a Saturday either, right? I mean, it really it depends on your setup, and I think it's fair to tell people that live in a 100-unit complex that they can't be playing drums. You're not discriminating against anybody, and that's probably a rule you want to have. But it's really dependent. If this probably isn't any of you guys, but if you had one of these. If you had a place where there's a bunch of nurses, right, they're going to be coming and going at all hours of the day, depending on the shifts that they're working. Well, the rules may be a little bit different than, where you've got a bunch of senior citizens living or where you've got a bunch of Mercy Group students living. So it's really, really dependent. But that's why John said maybe for each complex that you have, you tweak the rules a little bit to address
and
it.
if you have a tenant that is all of a sudden making noises and you don't have any noise regulations and you're really afraid that if you impose some rule now, he's going to say, well, if I'd have known that, I never would have rented from you, and he's going to sue you and everything. Let's be smart. Let's wait until a month before his lease is up. When you send him a renewal, send him the change in the regulations along with renewal. And if he doesn't want to renew, he won't sign it.
Yeah, true.
Thanks, Jamie. Nice question.
Thank you.
Anything else?
Good. All right. Well, we're going to shut this down then because I want to go home. We'll send out the slides. We'll send out the relevant links. Give me a couple days to put it together. But we'll get all this in. We'll send out the recording to everybody. And then, you know, we're waiting on more guidance on the rent relief program. We're waiting on guidance on a couple other issues. So when we, you know, we're waiting on Judge Walsh on the Judge Carney issue. So as these things come in, we'll keep you guys updated and keep an eye on your emails. And hopefully we can get you collecting all of your rent again very soon. Cool.
Good night.
All right. Thank you, everybody. Have a good night.